Hi guys, it's Jennifer again. This is video number 5 in the series Legal Pocky on YouTube. It's about fraud in Toronto. And this is just a progression of the criminal case. You have an arrest, bail or no bail, lawyer for the prosecutor or prosecutor for the Crown. There is a preliminary trial. I was told by my lawyer, G.Peter that this was a chance to see what the prosecution had. I also found out later that if evidence is produced to show innocence beyond a reasonable doubt, that the case would be dismissed at this point. The bank's lawyer and my lawyers had all been given evidence in March of 2002. All of the invoices for the companies have been turned over to them to support what was in the affidavit of Roddy Allen. The preliminary trial is set for July 2nd, 2002. On May 31st, Suhail Akhtar, he was the prosecutor, goes to the court trying to revoke my bail. He had additional disclosures contained in Volume 5 to deliver to me and asked the judge to issue a bench warrant because I was due in court on that day. The court date I had was for June 7th, scheduled by his office. I got a frantic phone call from my lawyer and made it to the courthouse in the nick of time. The judge apologizes and Akhtar sniggers like an idiot, knowing that he was caught in his lie. I don't recall the name of the judge, but I remember the comment she made. She said, "I'm going to keep my eye on this one." Volume 5 contains forensics. Of fingerprints and handwriting. The checks for the businesses were checked for my fingerprints and handwriting compared to see if I had forged the signatures or if I was the one handling the checks. There was no smoking gun in Volume 5. Plus, they had the affidavit of Roddy Allen, but they were still trying to say I had committed fraud. Peter Abrams knew a little of the case, but we had no detailed discussion. Here is a quick overview of what is happening up to this point. I was arrested on May 1st by the police. On May 18th, the bank civil lawyers turned up at my home with a notice of motion and a warrant to search my home, issued by one Judge Wilkins, stemming from an ex parte motion by the bank's lawyers. That I will discuss in detail in the next video, video number 6. From May 2001 to June 2002 of the following year, they threw every motion they could think of at Peter Abrams. They were also granted discovery by Wilkins. They were scheduling discovery just about every week until December of 2001. Plus, I had all of the criminal processes. In the interim, a deep discussion of the case did not take place between Peter and I. There was absolutely no discussion or preparation before we attended court on July 2nd. Before Judge Lipson, I was intrigued to hear Suhail Akhtar gushed to the judge about how he and Peter Abrams had narrowed the issues considerably. Peter then tells the judge that his client knows what he is about to do. Now I'm listening very closely, wondering what he is about to do, because we certainly did not have any discussions on what he was going to do. In fact, he was asking about the civil case, not the criminal case before the preliminary trial. He then proceeds to ask some very stupid questions. Mohammed Sharif was the only witness. Peter starts talking about the budget, but he has no idea how it related to the RFA and forecasting of the projects. I had never discussed the budget with Peter, so now I'm wondering, where did he get his information from? Mohammed tells Peter that he only found the select company after the Christmas holidays. Peter at this point has no idea that Mohammed had signed off on all of the purchase orders for the select company and that the purchase orders are available with his signature. Mohammed was committing perjury on the oath. Peter then asked the dumbest question of all. He asked, could the equipment from the Twisted Pair Cables Inc. for the M-Banks project have been stored in Alberta and then shipped to Toronto? I had briefly discussed how the Twisted Company had come to be, but he was not in possession of backup evidence to show another order had been initiated under the same system to sidestep the 8% provincial sales tax. Peter also knew it was not a matter of storage, so why ask this silly question? I had no idea if Peter was in possession of the email from John Haas, but that email was generated in 2001. He was certainly in possession of the affidavit of Roddy Allen, because I went to his office to look at it. I did inform him that I was not concerned with the contents, as evidence existed to prove that the bank knew and had approved of these orders. He knew nothing of the RFA and the process. Of Calby, he makes no mention. Heather Clark-Smith was in the courtroom. Judge Lipson bounds over the case for trial. Suhail Akhtar nor Peter said a word about the evidence in the affidavit of Roddy Allen, and Mohammed Sharif was not questioned about it. Like I said, copies of the actual invoices were given to the bank's lawyers Ian Roja in March of 2002. Peter also had access to all of the invoices. You always hear lawyers say, you should never ask a question you don't know the answer to. I wanted to ask a few questions, and one had happened at the preliminary trial. It certainly appeared to me as though Peter had just torpedoed my case, or at least he was trying to. After I left the courthouse, I called Peter's office to speak with him, but for one whole week, I got every excuse in the book. I started looking for a new lawyer because I suspected Peter had made a deal with the Crown without my knowledge. This is what is called legal malpractice. In August 2002, I retained Aston Hall as my criminal attorney, and Stephen K. Stoffer was recommended as the civil lawyer. Years later, I would come to know that Peter had also made a deal with the Bank of Montreal civil lawyers, also without my knowledge. When I retained Peter, he was a practicing lawyer for 23 years. He only had scant knowledge of my case. Yet, in 2001, he went to a weekend in the Muskokas with his wife and met up with Jonathan Baker, one of the lawyers for the Bank of Montreal. He was on the civil case, and Jonathan's secretary. I firmly believe this is where he struck a deal with the bank. Suhail Akhtar's actions amounted to prosecutorial misconduct. He removed all of the exculpatory evidence. All of the other lawyers would follow in his and Peter's lead. This was a malicious prosecution from the beginning. They never had probable cause. Then he was given the affidavit of Roddy Allen before the preliminary trial, which proved that no monies was stolen from the bank. Yet he was still trying to revoke my bail so he could get an unfair advantage. This was blatant corruption. Peter and Suhail Akhtar committed criminal obstruction. What is the obstructive act? They were removing exculpatory evidence from the investigation and secretly dealing. Was there evidence of corrupt intent on the part of Peter and Suhail Akhtar? You be the judge. Do you think a removal of the evidence that will acquit me and quash his case is based on truth and justice? They both exhibited extreme prejudice and a reckless disregard for the truth. Akhtar wanted to win, and I guess he knew he would be sued for his dishonest press conference. But why would Peter do something like this? In 2014, there was an issue with Peter Abrams and the Law Society. It was disclosed that the Bank of Montreal was prominent in this matter. Was this a favor to the bank? I remember Peter not subpoenaing the letter sent to Chase Bank for the removal of monies from Select Technologies. I also remember him dragging his feet to request the funds for my trial, and me having to let go Elizabeth Nadeau, the lawyer I had tried to retain for my criminal trial. He did show me a letter. I was not allowed to hold it, but he said he had written to the bank's lawyers. I never got a copy of it. Suhail Akhtar is now a judge, and I do not hesitate to call him a dishonest hypocrite. While this is unfortunate, he is not the exception but the rule. Most other judges I will profile are just as nonchalant in their unapologetic corruption. This is how it keeps on keeping on. For example, the lawyers who knew of what Suhail Akhtar did, when they go before him now, they have preferential treatment. Because now they'll say, well, I know what you did to Jennifer. He is now their official pool boy. In early 2018, Akhtar issued a rebuke on another judge for misrepresentation of a Supreme Court ruling and ordered a new trial. Akhtar wrote in his decision, he said, the court did not sanction the elimination of fundamentals of criminal justice. And what the judge did strongly suggests by his comments that he did prejudge the matter and there was a reasonable apprehension of bias. He ended his reversal by writing, what had happened was a serious violation of natural justice. Well, if people could die of hypocrisy, Suhail Akhtar would be stone dead. You saw what him and Peter did with my evidence. Were the fundamentals of criminal justice eliminated? Was it natural justice what he and Peter did? The other judge did not misrepresent the case law. Even I, who never went to law school, knew what the case law meant. This judge was just abusing his power. The judges have no accountability, so they run helter-skelter over the rule of law. The oversight body seems to be in a permanent holding pattern, almost comatose, between half dead and dead on decision. Akhtar should never have been promoted to being a judge. He should not be in his position, and that other judge, Richard Blouin, should be fired or sent to traffic court. He is a problem too. Intermittently, you hear of the Liberals trying to initiate some sort of reform. In 2008, Dalton McGuinty with Roy McMurtry and Alvin Curlin tried their hand at youth crime. Legal Aid is another entity that eludes reform. And don't mention the civil court system. That defies explanation. Criminal trials are too delayed. The Supreme Court delivered a remedy, but is that the right one? The experts then start fighting about who is right, and then they implement superficial fixes based on their understanding and then the real solutions retreat further and further into the future. When it's the conservatives' turn, they implement punishment because they can. And this is not based on facts either. When Jody Wilson-Raybould became Justice Minister, she started to seriously look at the criminal code in 2017 and what updates were required. This was a good start. In 2018, she sat down with the experts like sitting judges and criminal lawyers. Then we all know what happened to her position. You can read about that in number 2 and number 3 video titled Government. Then a report comes out about the Trudeau's government falling short on justice reform. Bill C-75 is a prime example. No matter how hard Trudeau or Jody tried, they would never be able to implement more than just superficial band-aid solutions, which is why Toronto is describing the system as a toxic cesspool. The simple fact is that there can be no solution, no meaningful solution until you know what the real problems are. These experts don't know what is happening in this system, and they are dead set on not looking in the mirror to see their complicity and their failings. But the population who have had their lives destroyed by a corrupt system have first-hand knowledge of what is taking place. This is why I'm putting my experiences here to show you an example of what is required. Factual data is required to make meaningful changes. I cannot stress that enough. This is why I'm begging you to come forward, because if you don't, this will happen to your children too. There are no stats for prosecutors and judges who run afoul of their duties. The Attorney General's office they point to Upper Canada Law Society as a mean for stats as they discipline prosecutors. They also claim that they have no idea how many complaints have been received. Freedom of information requests are immediately denied. In other words, we don't care, bugger off. Welcome to the justice system in Toronto. A big fat nothing. The cesspool grows even wider. This is what we must change. Please come forward with your experiences. We need to burn this cesspool up. Video number 6, which is the next in the series, will be about the bank's lawyers, Ian Roja, Jonathan Baker, and David Altshuler from the law firm of Teplitsky Colson.